We're starting the next panel, and I'm very pleased that my colleague, Professor Suzanne Katzenstein, is moderating this. Suzanne is a research scholar and project director at the Duke Human Rights Center, which is part of the Kenan Institute of Ethics here at Duke University. But really, she's a Duke alumni, went to undergrad at Duke. She taught here in the law school. She is one of these people that not only has her JD from Harvard, but she also has a PhD in political science from Columbia University. She's recently published an article which is really interesting. I brought it up very quickly and took a look at it. Dollar Unilateralism, the new front line of national security, and it's talking about how the U.S. government is leveraging the dollar to influence foreign banks as a strategy to isolate targeted entities and track illicit financial flows. Really very, very interesting. She teaches here. She teaches a business class and a human rights class. And she'll introduce the rest of our esteemed panelists, including my friend Elisa Massimino, who will join us via Skype. She did her darndest to get here, and if you know anything about Elisa, she's the CEO of Human Rights First. If it was physically possible, she'd be sitting in a chair here. But I'm so glad that, Lisa, you could join us at least by Skype. Suzanne?
Thanks, Charlie, for the introduction. So this panel is titled Human Rights in the Age of Forever War, and it's a real honor to introduce our three esteemed panelists. I'll do so in the order that they'll be speaking. They'll then present in turn, and then we'll open the floor up to questions. So first we'll hear from Elisa Massimino, who, as Charlie said, would have offered to drive if she could have to join us in person, but has generously agreed to join us via Skype. She's the president and chief executive officer of Human Rights First, which is one of the nation's leading human rights advocacy organizations. She joined Human Rights First as a staff attorney in 1991 and helped establish the Washington office. From 1997 to 2008, she served as the organization's Washington director. As a national authority on human rights law and policy, she's testified before Congress dozens of times, writes frequently for mainstream publications and specialized journals, and regularly appears on major media outlets. Since 2008, The Hill, which is a well-known Washington newspaper, has repeatedly named her as one of the most effective public advocates in the country. Andrew Carswell currently serves as the senior delegate to the U.S. and Canadian Armed Forces for the International Committee of the Red Cross. In that capacity, he advises combatant commands, deploying operational units and advanced military colleges regarding the ICRC's field interaction with armed forces and the international legal framework governing military operations. Between 2009 and 2011, he served as the advisor for the ICRC's Unit for Relations with Armed Carriers in Geneva, where he supported 25 armed forces delegates worldwide regarding their efforts to implement the law of armed conflict at the national level. Between 2006 and 2009, he was based in Pretoria as a regional delegate to the Armed Forces of Southern Africa and the Indian Ocean, and he has spent or served on ICRC operations in Jordan, Afghanistan, Rwanda, South Sudan, among other places. Lastly, we'll hear from Jayne Huckerby. She's an associate clinical professor of law and director of the International Human Rights Clinic here at Duke Law School. In 2014, she was the expert advisor to the Organization for Security and Cooperation in Europe and the Global Counterterrorism Forum, Initiative on Women Encountering Violent Extremism. She's also a researcher on the gender counterterrorism and violent extremism for the UN Global Study on the implementation of UN Security Council Resolution 1325. She recently co-edited a volume titled Gender, National Security and Counterterrorism, Human Rights Perspectives. And then this past year, she authored a chapter titled Terrorism, Gender, and International Law for the Handbook on Terrorism and International Law. I'll just say on a more personal note that speaking to some of my former students at Duke Law School, Jayne is a beloved professor and mentor. And if you speak to students from her clinic, they talk about the clinic as the defining, even transformative experience for them here at the law school. And there are many reasons for this, but I'll name just one, which is when Jayne takes students to places like the Middle East and New York City, she encourages and expects her students to fully participate in the event, in these important advocacy moments, rather than kind of relegate them to the sidelines. So this is truly the model of learning by doing, and students and colleagues deeply appreciate it.
Okay, hi there. I'm so happy to be here, well, with you, but I wish I was there in person. As Charlie said, the airlines did not cooperate. But I'm really especially pleased and congratulate Duke and Charlie for pulling this together, because as somebody who's been working on these issues in Washington for, a long time, certainly since way before 9/11, but consistently since then, looking at the intersection of human rights and the laws of war and counterterrorism. I find that so many of the debates that we have really mask the underlying issues. So whether we're talking about Guantanamo or drone strikes or military commissions, and so much of what we're debating, really these are the symptoms of an underlying problem, I would assert, and I will, that we are stuck in a quote, forever war. And that has really undermined the cause of human rights. I also would argue that it's hurt the effort to combat terrorism. Those two facts are related, because the most effective weapon the United States has in the battle against terrorism isn't war, forever or otherwise. It's leadership on human rights. That's the main point I'd like to get across today. And the forever war that the United States has been engaged in has weakened that leadership. I also want to say at the outset that while it's important to address the fundamental causes of terrorism, and I'm going to say more about that in a second, it's obvious and also really important to recognize reality. There are vicious militants killing thousands of people, including Americans. They're committing mass atrocities that in some cases may rise to the level of genocide. They are sowing sectarianism and threatening to further destabilize the whole Middle East region, and they represent a grave human rights crisis. So while it's true that we can't kill the crisis away, I think it's also true that these groups can't be allowed to slaughter with impunity. So force is sometimes necessary. Ideally, as the Obama administration has recognized, it'll be indigenous forces doing the fighting on the ground, and when the U.S. uses military force, it ought to tailor that to meet the threat and act with the firm grounding in international law, but too often that has not been the case. There's a good reason to believe that the U.S. government has violated the crucial principles of both distinction and proportionality, which I know you'll hear about from Andrew and later in the day, although it's hard to say to what extent because of a real lack of transparency that is itself part of the problem. You know, one example is in response to the widespread criticism of the drone strikes, President Obama instituted a rule to prevent civilian deaths, but for Syria and Iraq, he exempted himself from that rule. And now, after months of strikes in Syria and Iraq, the U.S. government has not officially confirmed the death of a single civilian killed by a U.S. strike. So that is not the way to win hearts and minds, and I think that's one example of the problem that we're facing. So I would say that the armed conflict that began right after 9/11, what we're referring to, I think, here as the forever war, has really had a profound impact on human rights. I'm not going to get into the legal questions or the political debate about the authorization for the use of military force, because I know there's a terrific group on deck later today that's going to talk about that. But but let's look at where we are. I mean, thanks to the 2001 AUMF, the most powerful country in the world, is finding itself now in 2015 in what seems to be a permanent state of war with virtually no geographic limits and against an unclear and ever-growing collection of enemies. From a human rights perspective, a protracted state of armed conflict is problematic for a lot of reasons. It triggers laws on targeting and detention, for example, that you'll hear about later today, that provide a less stringent human rights protections for people, and it creates political and perhaps legal justification for measures like indefinite detention and military courts and broad interpretations of anti-terrorism laws that wouldn't otherwise be available or acceptable. So in some ways, it's undermining the rule of law as we see government officials, in the name of fighting a war, cut legal corners and pass over proven civilian institutions of justice in favor of ad hoc military commissions, for example. And it seems to compel a level of secrecy that risks corroding our democracy. So the secrecy and the militarization bleed into domestic law enforcement and other government functions. I could go on, but I think you get the picture that, while war is sometimes necessary, wars, as President Obama has repeatedly said, and he's not the only one, are meant to end. And so when they don't, and we have a situation which is the framing for this conference where we have the forever war, that's obviously a problem. And human rights violations by the US government are really in some ways different in kind. Now, I lead an organization that has as its mission fostering American global leadership on human rights. And one of the reasons why I think that's so important is that when the U.S. government plays an outsized role on many issues in the world, but on human rights, where it has been such a leader in establishing the norms and standards for the global human rights system, it's obviously a much bigger problem when it falls short. Obviously, any human rights violations are harmful in and of themselves, that cause suffering, but when the U.S. violates rights, it really has a broader impact because of our global leadership. Even with all our imperfections, I think the United States really continues to be looked to both by human rights activists and by other governments as setting the standard. And the forever war has sapped our country's moral and political force in many ways on the world stage. Violations by the United States provide cover for abusive governments. They thrive on what they see as American hypocrisy. It's not for nothing that a lot of these regimes have called their crackdowns on legitimate political dissent a, quote, war on terror. The capacity of the U.S. to lead globally on human rights really derives from our willingness and ability to lead by example and to live up to our ideals. Several years ago, I brought, we had a summit in Washington where we brought together human rights activists from all over the world, and they had lots and lots of problems, from coming from Russia and Colombia and Indonesia and all over the place. And I brought them to the White House for a meeting with President Obama, where they were going to articulate what they wanted from the United States. They all had very different struggles, but they spoke with one voice to the president. What they wanted, above all, was not money or rhetorical support. The most important thing that they thought the president could do to help each of them in their own struggles for human rights in their own countries was to bring U.S. counterterrorism efforts into line with international law. To them, that was the most important thing. So the forever war is not just bad for human rights, though I think it's also bad for the struggle against terrorism. Violent extremists and repressive governments feed off of each other in this kind of mutually reinforcing and deadly cycle. Governments that resist calls for more inclusive and representative government, restrict the basic rights of their people, and flout the rule of law, fuel grievances on which violent extremism feeds. Systematic repression closes down public space. It quashes open and peaceful debate. And in those conditions, moderate, nonviolent dissenters are silenced and extremists thrive. This was the message that the president gave in his speech at the Summit on Countering Violent Extremism a week ago. And they, in turn, these governments turn state violence into a justification for violence. This is the violent extremism and extremists, and they gain supporters when they're seen as kind of the bold opponents of unpopular governments. So we work with an international coalition of military and law enforcement leaders who promote counterterrorism policies that respect human rights. And in advance of the summit that I just mentioned, a group of them, including military and intelligence leaders from Pakistan and Kenya and Senegal, put out a statement urging President Obama to address the human rights abuses that cultivate extremism in this summit. They wrote in this letter, this is a quote, "Governments and security services that violate human rights and use abusive and heavy-handed security and counterterrorism measures, including torture, disappearance, extrajudicial killing, mass arrests, and violent responses to peaceful protests, are undermining their own stability and inflaming extremism by alienating and radicalizing their own citizens." So, the challenge is that most of the countries that are contributing directly to violent extremism are close allies of the United States. Many of them were represented in that room that Jayne and I were in last week. Some of them are official members of the US-led anti-ISIL coalition. So the extreme repression in countries like Saudi Arabia and Bahrain and Egypt fuel extremism. So, while the world recoils in horror as ISIS beheads hostages, just last week, we learned that Saudi Arabia is going to behead someone for ripping up a piece of the Quran, part of a series of such official decapitations. Saudi Arabia and other governments also disseminate anti-Semitic, anti-Christian, and other sectarian propaganda through their official and unofficial media outlets and their school textbooks. They are training the next generation to hate. They have funded a worldwide network of madrasas and mosques that likewise promulgate an ideology of hatred. But the support of these countries for extremism is even more direct than that. The well-documented truth, one that was acknowledged publicly by Vice President Biden and General Dempsey, is that Saudi Arabia, Qatar, even Turkey have supported extremists in Syria. For example, the leaders of al-Qaeda's affiliate in Syria have flown to Doha for consultations with Qatar's military and political leadership. And Saudi Arabia has allowed extremists, some of them just out of prison and facing travel bans, to fly to Syria. And then there are the hundreds of millions of dollars that have gone from these countries to extremist groups with the tacit support of these governments. Security needs will necessarily bring the United States into alliance with unsavory governments. I'm certainly not saying that the United States cannot work with these governments in some ways, but this is ridiculous. This is undermining our supposed joint objective of countering violent extremism. We are not going to win if part of the strategy of our allies is to violate human rights. So we need a new policy, I think, the United States. And the U.S. has wrestled with this paradox for many years. Both President Bush and President Obama have recognized the connection between repression and violent extremism, but they have nonetheless continued to operate in a relatively uncritical partnership with repressive allies on this theory that it's a zero-sum game and that there's some kind of balancing that needs to happen. The primary rationale given is stability, but the Arab Spring uprisings showed that the stability, so-called, that was created by repression is really an illusion. So it's time, I would argue, for a new approach, particularly to our relationships in the Middle East, one that recognizes that respect for human rights is essential to security. If international cooperation in the fight against violent extremism is solely or even primarily a matter of kind of operational cooperation between military and security forces, it's gonna fail, and to the detriment of security and human rights. The U.S. government should consistently be condemning and pressuring those countries that have actively restricted public space and cracked down on civil society and spread religious hatred, and it cannot abide support for extremists from its closest allies. That has to stop. And the U.S. should be focusing on building counterterrorism partnerships that capitalize on allied resources while fully enforcing existing human rights conditions on aid and directing assistance specifically to promote respect for human rights. At the same time, it has to take a broader view of the battle against terrorism, recognizing that fostering the growth of freedom is going to enhance security over the long term. Let me just give you one example and I'll close. You know, the U.S. Treasury takes the lead on the government's role in the Financial Action Task Force. This is an international organization set up to prevent money flows to terrorist organizations. And some of the actions in the overregulation there has led to the crackdown on peaceful activism as repressive governments use those standards to restrict civil society funding. In other words, an anti-terrorism measure is enabling repression, which in turn hurts the struggle against terrorism and undermines human rights. So we have to be smarter, and I think we can do better. I think I will stop there, and I, again, really want to thank you for making the arrangements so I could speak with you today, even though I can't be there in person. I look forward to participating in the Q&A. Thanks, Suzanne.
Thank you.
Okay. Excellent. Ladies and gentlemen, good morning. First of all, I want to say, Charlie, thank you so much for the invitation. Very much appreciated. I also wanted to actually kick off here very quickly with a short retort, and I know I'm not here to do that, to what Professor Schmidt just brought up. Mike, I think you had an excellent presentation and is always extremely balanced. I just wanted to maybe give a little bit of context on the issue of continuous combat function, because that in fact relates directly to the topic of this discussion, which is the juxtaposition of international human rights law and the law of armed conflict. And the example that was given is maybe one that I can begin the discussion with. The example was the one of the IED maker. So here you had ICRC coming to the discussion, making the argument that an IED maker does not have a continuous combat function for a party to the conflict. And the reason for that is if you look at the three different tests of direct participation in hostilities, the second test is there has to be a direct causation between the act in question and the harm that's caused. So the concept of, if you have an IED maker and he's solely an IED maker and he's not a rifleman at the end of the day, that's his sole vocation, then the IED maker is analogous to somebody who works in the military-industrial complex in Virginia, in the sense that he's sitting on a pile of military objectives, as defined in Article 52 in AP1, but he himself, when he walks home at the end of the day, is a protected civilian. Again, only if that's his sole function. If he also carries a rifle, there's no question he can be brought in under that category and he can be targeted in the first resort. So if you take a look at, if you talk to, I'm a former JAG officer, and if I were advising a commander on the issue, and I have somebody whose sole role is, and I also want to differentiate this from the IED maker who's also deploying those ordnance. If he's actually digging the hole and putting them on the road, then of course he's met the direct causation elements, and he can be considered to be DPHing, in which case he can be, again, subject to lethal force in the first resort. But the man we're talking about, if he doesn't reach that test, I'm advising the commander that you can still employ deadly force against those military objectives, and if he happens to be in the area, well, he's going to be legitimate collateral damage. And that goes then to the question of zero collateral damage policies, which some NATO members had, for example, in Afghanistan. You can't actually engage in that sort of logic if you start from the proposition that no collateral casualties are permissible. But there was a lot of talk at the time about revolving doors. And I won't even mention a name, but I heard a senior British scholar who talked about, I usually agree with ICRC's products, but this revolving door I can't live with. This idea that you could be a fighter by day, a farmer by day and a fighter by night, and you're protected when you're a farmer by day. I stood up and said, it's exactly the opposite. That ICRC came to the conclusion that if you've gone through that door on a recurring basis, so if you're directly participating in hostilities on behalf of the party of the conflict on a recurring basis, that door can actually lock behind you, because you will then have a continuous combat function, and you can be targeted 24/7, subject to a more controversial provision, I think, which is the 9th recommendation on the amount of force you can use. We can bring that up a little bit later, also in the context of whether human rights law feeds into that. But I just wanted to quickly respond to Mike on that interesting point. Now, what I've got here is really more of a discussion of this dividing line writ large. For those of you who aren't familiar with ICRC and what we do, of course you see us out doing assistance work and protection work and prison visits and so on, but a big part of our work in the last dozen years or so, specifically in relation to Afghanistan and now in subsequent conflicts, is a dialogue, a confidential dialogue that we have with all the parties to the conflict as feasible regarding their obligations under the laws of war, yes, but also under human rights law as applicable. Now, that dialogue is not aimed at getting these people before an international tribunal. What we do is we ask the armed forces in question or the non-state armed group in question to look into these allegations, to investigate internally and to carry out their own internal discipline as appropriate, but to report back to us confidentially as well, so that we can have an idea as to how that's proceeding. And that comes directly out of our mandate under the statutes of the Red Cross, Red Crescent movement. So it's not something that we do entirely out of the goodness of our heart, but it's actually built into that. Now, when we talk about conduct of hostilities, of course, we're talking about laws of armed conflict, or IHL, or laws of war, depending on your perspective. Geneva people tend to call it IHL. With a military background, I tend to call it LOAC. It's all the same thing. I put the term law enforcement in quotations for a reason, because often the situation that we're talking about here, when I'm talking about law enforcement, I'm actually talking about the situation of using force outside of the conduct of hostilities, whether there's an armed conflict on the territory or not, or whether you're talking about a country for which there is no armed conflict, where military is using force. We'll call that law enforcement, but in fact, there might be no law to enforce. You might be in a situation in which you're in Northwest Africa and you have absolutely no law to appeal to, and that's hardly the point. The point is that you've got force protection measures. You've got a group of people who are now coming up and protesting against your forward operating basis, just in a hypothetical, and you're now going to be using graduated use of force against those people, not lethal force, because they're not parties to an armed conflict. So we'll call that law enforcement loosely. If you look at U.S. ROE, the Standing Rules of Engagement, they're going to be talking about conduct-based targeting, which is similar. Sometimes we find that we're speaking a different language. So as we come to the table and have this discussion confidentially with states, non-state armed groups, we're sometimes speaking a different language, especially in relation to states. We will come in, you'll see the ICRC delegates will walk in with their Geneva Conventions in hand. They'll walk in with their ICCPR, their International Covenant on Civil and Political Rights. They'll refer to particular articles of international law and say, look, there's a potential violation here. Can you please rectify this? And the other side is saying, look, we understand that there are treaties out there, but we see those as feeding into other instruments, so into the operational order, into the annexed rules of engagement, and so on. And it's not always an easy discussion to have. So right away you have a linguistic issue. One's talking about hostile intent and hostile act, and the other one's talking about specific articles of international treaties. And then, of course, there's the predispositions that we bring to the table. So as ICRC, we've been out there as an organization for 150 years. We've got operational experience, no question about that, but it's always been through the lens of the beneficiaries of the law. So it's always been through the lens of civilians. It's also through the lens of detained military personnel, wounded military personnel. But the focus tends to be on the civilian population because that's where the bulk of the work is. When we talk to our counterparts in the military, they're looking at it from that perspective as well, but their primary perspective, and you can correct me if I've got that perspective wrong, I've been pinging it off U.S. forces for the last 4 years, But their perspective is first and foremost, I'm out there to protect the 18-year-olds that I'm putting into harm's way. So if you want to put that in legal terms, we're talking about a balance between military necessity on one side and humanity on the other, which is an oversimplification because, of course, all of you in uniform are taking humanity very much into account. So if we look at the spectrum here, from left to right, this is a very basic and probably misleading diagram, but if you look at the spectrum of conflict from peace to outright international armed conflict, so that white bar on the right side, there you're talking about state versus state conflict. We've got all 4 Geneva Conventions applying. You've got additional Protocol 1 applicable, where the parties have ratified that instrument. And at the same time, you have limited application of human rights law. But as I mentioned, you might have an armed conflict happening on the territory, and then there might be situations where the use of force is governed by what ICRC would call human rights law. The U.S. government has different terminology, which I'll get into in one second. But that's fairly easy to determine in terms of legal classification, because a state fires a first shot against another state. As Pictet said, it's a disagreement between armed forces that leads to the intervention of their, disagreement between states leading to the intervention of their armed forces. It can be anything. You don't even have to have a shot fired. So that triggers all those applications because your first shot fired is, in fact, potentially going to lead to collateral issues. Potentially you're going to have wounded. Potentially you're going to have a detainee and so forth. The left side is a little more complicated. Here's where we are in Durham today. I'm not even sure if I'm in Raleigh or Durham right now. You can show my geographical knowledge. I'm from DC, so it's the center of the universe. Right? But on this side here, of course, with national law, if there's an insurrection, that we go out and start today, it's going to be captured by criminal law. It's going to be captured by human rights law. To the extent that human rights law sits theoretically above the national law. Now, that human rights law can, of course, be derogated from in certain circumstances. So you look to the ICCPR derogation provisions, and it can be done if there's basically a civil emergency that threatens the life of the nation. You can get into that discussion of derogating. That, in fact, doesn't really happen that much in reality anymore. But it's possible to derogate from certain provisions and not from, in the ICCPR, and not from the key core ones, such as the right to life. But of course, the right to life is a very relative thing, and it talks about the fact that the right to life still does account for the fact that there is warfare and that the laws of armed conflict can apply. So right to life is not absolute. Now, the key point in terms of getting over into the laws of armed conflict side, which is the red on the right side of that yellow bar, how do we get there? And the Tadic decision of the Yugoslav Tribunal Appeals Chamber 95 clarified that, and it's been built on since, mostly from that jurisprudence. But the concept is that you have to have a situation in which there's an organization of the parties, there has to be a sufficient degree of organization of the parties, and there has to be also an intensity of conflict. So if you meet those two things, you're going to cross the line. But A, those are difficult to apply in principle. Like that, the legal test is difficult. Secondly, there's all kinds of political motivation behind it. There are a number of countries in this world, which I won't mention today, which have non-international armed conflicts, but fail to admit that, and they won't admit it because of the fact that they see this as a matter of sovereignty, they see this through the lens of criminal law, and they don't want the international community getting too interested. To which we respond as ICRC, well, that's very interesting, but then you're going to have to park your helicopter gunships because IHL also gives you a certain leeway to use means and methods of warfare, which you don't otherwise have. So it's maybe not a bad thing to have a situation classified as an armed conflict if it is, in fact, an armed conflict. But this diagram gets skewed and more difficult as you start thinking of, well, where is the battlefield? And if we have a moment at the end of this, I'll try to discuss that a little bit. Professor Schmitz written an excellent article on that issue. ICRC is just coming forward. Yelena Page from our thematic legal division is writing a paper on that as we speak, or it's about to be published on this issue. But it's an area where there's not much state practice, or there's pretty much none, and we have an opportunity as ICRC to try to enter into a policy debate. But there is some law, and the law tends to be sitting in the balance, depending on the way in which you look at it. But to give you a concrete example, if you've got a member of ISIS who walks away from the battlefield, somebody from Iraq or Syria, he's a fighting member, declared, and so on, and he finds himself back home in Northwest Africa somewhere in a peaceful state. The question is, can you use lethal force in the first resort against that person? Well, that's a difficult question that revolves around the classification of the conflict. So I'm going to try to move quickly here because I tend to be verbose. So if we talk about, again, this dividing line between the two different frameworks, conduct of hostilities, of course, we're talking about the relationship between parties to an armed conflict, also the relationship between those parties and civilians who directly participate in hostilities. And this is where you look to the notions of distinction, which you're all very familiar with, proportionality. And here we're talking about a specific version of proportionality to be distinguished from jus ad bellum proportionality and to be distinguished from human rights law proportionality, very different concepts. In laws of armed conflict, we're, of course, talking about balancing concrete and direct military advantage on one side with the anticipated collateral damage to civilians on the other. Now, the law enforcement, again in quotes, is covering all situations other than armed conflict. And here, of course, we're talking about graduated force. So the law tells us international human rights law, now referring to that body of law, not referring to where Americans are currently referring, is lethal force is only available where strictly necessary to protect life against an imminent threat. So in other words, you have an obligation to try to get the situation de-escalated and to use means which are proportionate to the amount of force that is being used. So you look at concepts, when you talk about necessity in human rights law, you're talking about only using force when absolutely necessary in self-defense. You're talking about proportionality of means. Somebody is swinging a baseball bat at me or say something even less than that, I'm not going to shoot him in the head or unless it's a threat to my life, and so on. So it's a very different concept, and that's derived, again, the international law from ICCPR, and you've got a very good soft law instrument called the Basic Principles on the Use of Force in Firearms, or BPUF, as it's known. I think it's one of the great acronyms in international law. And BPUF is recognized by most to be customary and binding norms and in law enforcement operations by law enforcement officers, which are defined as anybody, including military, when they are carrying out law enforcement duties. Now, let's compare and contrast that with the chairman's standing rules of engagement. The standing rules of engagement talk about conduct-based and status-based engagement. So what does that mean? Well, they're not that far off in terms of discussion, but we have to be able to figure out, certainly as ICRC, where is the nub of the problem if there is an issue. And when we talk about conduct-based, so we're talking about a right of individual unit self-defense, very similar to the notion I just talked about, graduated use of force in human rights law, but here you're talking about a hostile act and hostile intent. There's not that much sunlight between hostile act and the human rights law notion of self-defense. Here you have an attack, and there's a response, and it's going to be proportionate and so on. So that's not probably going to enter into the equation as much, but it's the type of force you're using and the fact that it's proportionate that might be part of the dialogue. Hostile intent is much more difficult. And if you look at the notion of imminence, which is in the standing rules of engagement, it's actually not public. So I've never seen as an outsider what the definition of imminence is in the rules of engagement. But the imminence from an ICRC perspective, again, we derive it from human rights law. However, we're deriving it from human rights law, bearing in mind that the U.S. does not concede the extraterritorial application of human rights law. And that's a minority opinion, but a substantial opinion. There are a number of countries which follow that, but it is in the minority. The Human Rights Council has said that it does apply extraterritorially. You have to take a look at Article 2 of the ICCPR and read a particular provision disjunctively or conjunctively, and it will tell you that you can go either way. And the U.S. has been quite consistent that it does not apply, although Harold Coe, the state legal advisor a few years ago, was saying that there might be a move towards that. We haven't actually seen that manifested. So we're going to be talking, the applicable international law, we're talking ICCPR and BPUF again, and the U.S. is talking about general principles of international law, at least from what we've heard publicly. So general principles of international law, here we're going back to looking at all the countries in the world and their self-defense systems and their law enforcement systems, and that you always have a right of self-defense, but allows for a certain amount of latitude there, and again, we're always speaking a slightly different language. Status-based should, in theory, be less controversial, You don't have to, this is obviously only an armed conflict situation where you have a defined group, and the key question, of course, is how do you define membership in that particular group? Now, membership is exactly as Mike was alluding to a moment ago, from ICRC's perspective, it comes down to continuous combat function. The flip side, though, and what I think got lost in the DPH debates and some of the articles that came out after it, is that if you don't have a member, if you're not a member, that doesn't tie the hands of the military entirely. They are still allowed to use force, but it's falling under the other paradigm. And I would say, if you're going to make an analogy to the use of force in so-called law enforcement situations, it's going to be more like a SWAT team than a Bobby with a baton. And that's a really important distinction to make, is that you can, in certain situations, take our IED maker. Say you do want to get him off the battlefield, and he's been creating these, but you're not able to take him out collaterally, and you're not supposed to be taking him out. He's not the objective. You can go to, you can kick down his door, and you can actually detain that individual. And if there's a requirement for use of force in self-defense, up to including lethal, it can be done. But it's quite different. It means that the armed forces have to take more risks in those situations. And that comes down to this fundamental balance of military necessity versus humanity I was talking about a moment ago. So, the flip side of membership is who is a civilian, and then you're back into this human rights law paradigm according to ICRC. But as I said, it's quite nuanced. Interestingly, the civilians who DPH are not actually captured by status-based ROE, and they fall under the conduct base, which means if you actually, again, as a legal advisor who is lawyering the DPH study for a commander, I would make the argument that the DPH study allows you to go perhaps even further. Take the example of a preparatory act for direct participation in hostilities, which is not imminent. But preparatory acts are covered under the concept of DPH. So you could, in theory, have a targeting in depth behind enemy lines of an individual who's carrying out a preparatory act of DPH, even though your ROE wouldn't allow you to go that far. That really depends on the concept of imminence, though, which, as I said, I'm not party to. So there was a really interesting study at the end of 2013. Mr. Dick Jackson was here, was part of that study in Geneva. It's called The Use of Force in Armed Conflicts. I'd read it. If I were you, it's a very interesting read. It doesn't come to any firm conclusions, but what the experts did come to was this agreement, roughly an agreement, that the main, if not the only legal criterion for determining whether a situation is covered by the conduct of hostilities or law enforcement paradigms is the status, function, or conduct of the person against whom force may be used. So here, it's always been the notion of the bubble. Take the example of it's a few years ago, and it's downtown Kabul, or even today, it's downtown Kabul. You've got the Afghan National Army, who's been called in support of the ANP, who's overwhelmed. You've got the armed forces now in a crowd control situation, and while they're there, they see a single member of the Taliban who's in the group. He's identified, he's a known member, and there he is, he's amongst those people. Is that a law enforcement situation? Is that a conduct of hostility situation? And again, the human rights lawyers and IHL lawyers used to be looking at this and say, well, that's a bubble, that's a human rights law bubble, so clearly you have to use graduated force against that individual. He's not even armed. In fact, if that's a status-based target, then you can, in fact, use lethal force in the first resort against that individual, but subject to proportionality. And there are probably many situations in which it's going to be disproportionate to carry out an attack against that individual given the crowd situation, but it might be possible with a sniper, for example. I'm just trying to illustrate that there are different ways of looking at it. This is a particularly useful provision, I thought, because it really narrows it down to, where are my crosshairs aimed and who is the object of my force. So I'm not going to have time here, and I don't want to use up anybody else's time to talk about this, but I already brought it up a little bit at the beginning, and I would welcome any discussion later on. So thank you very much.
introduction, and a big thank you to everyone who travelled to Durham despite the weather. As an Australian, I found it traumatising to come from downtown Durham, so I'm very impressed by the effort here. Over the past 6 or so years, most of my work has really been focused on the human rights issues that are at stake in CVE, in countering violent extremism, which I've approached primarily from a gender perspective, which I think provides sort of a broader window or insight into those challenges. Much of my work has been at the regional and UN level, as Suzanne mentioned, but increasingly I've been looking at the USG on this. So last week, as Elisa mentioned, I organised and moderated a panel at the White House Summit on CVE on the issue of women and CVE. Also spent a lot of time in countries like Kenya, Tajikistan, Turkey and Thailand, looking particularly at US government CVE under the rubric of AFRICOM, PACOM, and also looking particularly at efforts to engage women, such as female engagement teams. And so just kind of a background as to what my intervention point is here. But in referring to CVE policy and practice, I'm really using CVE as a shorthand to describe a development of much more preventative whole-of-government approaches to countering violent extremism that really require the development of cooperative, trust-based relationships between security institutions and communities, including civil society. The CVE rubric, particularly in the last I'd say 5 to 7 years, has really involved recasting and reframing a number of areas that we don't traditionally consider to be security areas. So development, rule of law, human rights as security issues. It has also involved increasing the role of security and in many cases military personnel in non-security areas. And so, for example, one of the programs we looked quite closely at in a study that I undertook was the role of AFRICOM teams building wells in Kenya as a hearts and mind activity, and some of the challenges from a human rights and security perspective that entailed. So the first big set of human rights questions or challenges really has derived from exactly this issue of how to determine the dividing line between CVE and these other areas. So while a number of general activities, rule of law, promotion of human rights, development, gender equality, do have certain upstream effects in terms of building resilient communities and so forth, there's something very different about automatically and suddenly categorizing or labeling those activities CVE. These are very distinct communities of practice with very separate stakeholders, with very different ways of engaging with communities. And to give one kind of very concrete example is a lesson from the UK. So UK Prevent Programme, the Preventing Violent Extremism Programme, PVE, prior to its revision in 2011, was extraordinarily broad. You could get Prevent funding for anything. So, for example, people were putting up their hand to get Prevent funding for trainings on forced marriages and so forth. And that was the case both domestically in the UK, but also abroad in countries in which they ran PVE programs, particularly Pakistan and Kenya, for example. But the UK government quickly recognised the problems with that approach. It targeted certain communities, particularly Muslim communities. It securitized engagement with those communities. It meant, from both a human rights and security perspective, that people simply stopped engaging with government. It caused huge problems of trust with law enforcement and so forth. And unfortunately, I think what we're seeing in the US with the current CVE strategy of the US government is a return to that old Prevent, the pre-2011 Prevent. And so we do have a number of challenges around really trying to figure out where do we draw a line between CVE relevant, CVE direct, that's how it's often talked about in Europe, but it has particular implications, I think, for security institutions. So as I mentioned already, on an international level, we saw how the use of security institutions to undertake hearts and minds activities, such as AFRICOM in Kenya, really backfired from both a security and a human rights perspective. A second major human rights challenge really lies in the nature of private organisations and or individuals who are putting up their hand to receive funding pursuant to CVE, and sort of hinting at some of what Elisa was getting at as well. CVE policies and practice, community engagement, community policing, development, have really tended to engage formal, often male, traditional leaders to the exclusion of informal and often female leaders. Counter-narrative, the current buzzword on these issues, has often involved a search for credible voices, who can speak to those at risk of radicalisation that leads to violence. But again, that often has involved bolstering certain repressive voices in a community that may not be compatible with human rights. Similarly, what we saw in our studies has been really the concern of security actors not to upset local leaders, not to upset tribal dynamics. So, for example, only interacting with male leaders when undertaking development projects has really had an adverse impact in those communities in terms of enforcing existing hierarchies, and so forth. And finally, and this is true of US government practice domestically and abroad, also of UK practice too, to quite a degree, CVE methods have often, in perception or reality, been seen to favour one ideology, one imam, one community over another, which really raises significant human rights issues around freedom of expression and the proper role of government in religion. A third sort of major human rights challenge really arises from a disjuncture between CVE and other CVE-CT infrastructure. I'm echoing here the point made by Elisa. It would be difficult to overstate how much I have heard over the past sort of 7 to 8 years from people in the field and continue to hear how damaging US government counterterrorism financing rules are. These are rules that make it very difficult to fund grassroots organisations. They're almost impossible for women's groups to receive because they're often small, below the radar, don't have the capacity to absorb the rigorous auditing and reporting requirements that are required by US government funding. The result being that these rules are meaning that money is only going to gatekeepers in the community rather than grassroots organisations. And it's really not reaching the people that it needs to reach, and it's actually resulting in the shrinking of civil society in many countries. Again, the very group that the government seeks to engage elsewhere under CVE rubrics. And so anti-terrorism financing, both from people I interviewed in the government, people I've interviewed in sort of the women's rights defenders and broader community, is such an extraordinary core challenge from a human rights perspective that it really does cripple action in this area. I'm eager to leave for questions, so I'll finish with a couple of observations. One of the big challenges from a human rights perspective and in the human rights community, and I think also in the UN community as well, has been a real concern about securitizing and instrumentalizing certain areas of practice. So there is a very big difference between saying that women's rights are important as ends in themselves rather than saying women's rights only matter to counter violent extremism, which was very much a tenor of previous national security strategies of the USG, also very much the ways in which Clinton framed it at the UN in a number of engagements. That idea that you only promote development, you only promote human rights, you only promote rule of law because of its CVE outcome, really opens the door for bartering of those rights when it's seen not to help security. So women's rights, for example, rights of LGBTI communities are really put on sort of the chopping block when it comes down to governments talking to extremists or seeking to appease those groups. And that's allowed when we have this idea that women's rights only matter to that security end. I think the final thing that I would say is that CVE as an overarching framework for approaching communities has really altered, and the attraction of CVE funding has really changed priorities in communities that really don't map onto the human rights realities. And then again, let me give you a concrete example. I've looked quite closely at livelihood programs in Kenya. These are USAID programs that are designed to give livelihood to young, predominantly Somali men, to dissuade them from joining Al-Shabaab, right, to provide an alternative. But if you look at every community in which that money is being pumped into CVE and development, on the basis of risk, women and girls are much worse off on every measure. And so we have this sort of reinforcement of gender inequality and hierarchies in those communities. It just doesn't match what the communities are talking about as their major priorities. I said it finally, but I'm going to add another finally, because it's what you get to do when you're a professor. Is right now we have a real push to engage women in CVE, to engage mothers in particular. Is a big talk that came out of out of the summit last week. But really, I think that conversation has been taking place without a broader appreciation of the human rights factors that are at stake. Risk of backlash from violent extremists, compromising key stakeholder relationships. Also, the risk of having women be proximate to unreformed security services. Elisa mentioned, and I could not agree more, that a big challenge has been very often CVE has prioritised partnerships with governments that are just really not helpful from a human rights perspective. And so I think we need to be really thoughtful as we move forward on CVE and a broad notion of CVE to think about how people actually operate in increasingly restrictive, polarised and volatile environments. And I'll leave it at that and open up for questions.
Well, great. We have lots of room, lots of time for questions, and certainly covered the waterfront. And Elisa is still with us. I mean that literally. Nothing has happened, to my knowledge. There she is. Let's open it up for questions. Mike, since you were called out, I'm sure you have nothing to say on about 6 million things that were presented, but.
So, guess who this question is for, Andrew? So Andrew and I have been going around about this DPH for a long time, and I just thought I would give the other side of his comments. I want to start by saying, Andrew, I agree with every single word you said, except for the introductory comment. I think the ICRC has it exactly right on the law of all of these issues. I'm not in agreement with the ICRC on geography, but unfortunately we weren't able to get to that. And I think that is the new emerging debate in this area that will affect countering terrorism outside the battle space. Let me talk a tiny bit about the direct participation issues. You know, I think many of us do believe the bomb maker in Afghanistan or the individual making homemade rockets in Gaza is a lot different than the munitions worker in Flint, Michigan, because they are near the battle space and the weapons that they are going to create will be employed imminently in the battle space. But let's put that debate aside because that's really a factual debate. What's the nexus to the battle space? What I was concerned about was your comment where you said, well, you know, the bomb maker will eventually be in the factory, and when you drop a bomb on the factory where the bomb's being made or where the rocket's being made, then that guy will be taken out, has collateral damage, and because of the value of the rockets or IEDs, that probably is proportionate. My concern is that when we tell people that, and I hear that a lot, when we tell people that, what we're really trying to tell them is, listen, you need to find a way to kill a civilian, and this is how you can kill the No, I know that listen, we're buddies, but I keep hearing this argument, and people are interpreting it as, this is the way I killed the bomb maker. And in my view, if you do that, not you, if one does that, that's a subterfuge, and that's directing an attack against a civilian, and that's a war crime. So I know that's not what you meant, but I wanted to make sure that folks in the audience didn't go, aha, that's how I killed that guy. Second, I think that when I hear this argument about the bomb maker and near the factory, we often want to kill the bomb maker when he's away from the factory because we may not know where the factory is. So the way to shut the operation down is by taking him out while he's away from a location where we're intercepting communications, for example. We know he's there, we know he's involved in the activity, we just don't know where he goes. And I have a sense that the revolving door comment on CCF is not correct. Perhaps you can clarify. Well, you said when you go through the revolving door enough, eventually, you know, your targetable has CCF. But that's not what I was one of the experts. I spent 5 years doing this. That's not what it says. The revolving door issue only applies to individuals, and CCF only applies to members of organized armed group. So what makes you targetable all the time is never going through the revolving door on a recurring basis, according to the guidance. It's being a member of a group. And you can be targetable in the group if your function is a continuous combat function, even if you've never actually done anything. It's a status-based targeting. So I don't think the revolving door solves anything at all. CCF solves anything at all by going through revolving door a lot. And indeed, that's what the interpretive guidance says, because I looked it up. It's the beauty of computers. So I looked it up, and it specifically says that the revolving door of civilian protection is an integral part, not a malfunction of IHL. And those of us who are critical do find it to be a malfunction because What it means is no matter how many times you go through that revolving door, unless we can catch you when you're deploying to, executing, or deploying from, then you're just like a civilian and we can't touch you, even though we know that you are going through that revolving door next Tuesday and next Thursday and next Monday, unless we can establish that you're a member of an organized armed group.
Andrew, any response?
No, no. I mean, only 4 issues to very and no complexity in those issues whatsoever. Look, I mean, thanks for those excellent questions. Look, when it comes to the CCF and revolving door, I'll start with that. I wasn't suggesting that revolving door is the test for CCF. What I was saying is that the revolving door was created by Article 51 of AP1, and it's the unless and for such time as, and there was a time element there, therefore is a revolving door. What the study says about continuous combat function is that there are a couple ways of getting there. One is you can overtly show your membership through openly carrying your arms, distinguishing yourself, and so on. Another way of getting there is to directly participate on a recurring basis. It doesn't say how many times the study, that's open for discussion. But those who DPH on a recurring basis on behalf of a party to the conflict can at some point be deemed to have become a functional member, a de facto member of the armed group.
Only if you can establish the membership nexus first. Otherwise, it's a completely irrelevant consideration.
That's why I said on behalf of a party.
We have 60 more seconds on this particular topic.
So that's why I said on behalf of a party to the conflict. So I'm not disagreeing with you. Now, when it comes to the bomb maker and his proximity to the battle space, obviously, I'm not saying that he has ICRC is not saying that you should go and intentionally have collateral damage to civilians. What I'm saying is that if this individual happens to find himself in that situation, he's likely to be a legitimate collateral casualty. But like our Flint or Virginia man who walks home at night, he's a protected civilian. And you have to take precautions in relation to that civilian as well. So you have to take precautions. If that means targeting that factory at night after he's gone home, then those are going to be sufficient precautions and so on. But what I am saying is that somebody who works amongst military objectives, and this was recognized also in the study, is more likely to become a legitimate collateral issue, and that was actually written in there. Now, right, collateral.
Well, how about if we go on to, while you're thinking about that, Dick?
Hi, I have a question for Professor Katzenstein. You said Kenya building wells backfired. How did it backfire? What are the second and third order effects of the building wells? And is there a way that the military can do humanitarian civic assistance missions like that without backfiring, in your view?
That's Professor Huckerby, actually.
Thank you for the question. So the way, I'm thinking of a particular one or two examples, the ways in which it backfired. So the projects were undertaken by individuals who didn't have development expertise in the community. So when they went to consult with the community on building wells, they consulted with the men. And Development 101 will tell you that women are the people in the community that are responsible for collecting water and so forth. So automatically they're excluded from decision making. They would construct the wells at night, this is US military, surrounded by Kenyan security. That did not do a lot to build the trust of the local community in what was happening behind that wall. Then the wells, because they weren't done in consultation with people who actually knew, like local community leaders who were women, who could have undertaken these activities, a lot of them broke. Again, that did not help with the hearts and mind activity, did not positively dispose people toward the USG and toward the US military in particular. So we had this situation where there was no water, but also it had undermined the hearts and minds objective. From my experience, I don't think there is an appropriate role, and you have to be very careful about the dividing line between when the military can be engaged in sort of humanitarian efforts. I think in a context where you have a very strong and very effective aid community, such as we've had with USAID in Kenya, where they've been there for a very long time, where they will measure long-term outputs of projects, then there's no reason that role should not be handed over to USAID. And so part of the, I think the challenge in, particularly in the Kenya context that I'm thinking of, was a real concern that it was a short-term rather than long-term investment in the community. The community felt very much like they were being treated like idiots, in the sense of like, you're not here to purely help us. We understand there's a broader objective here. Why don't we talk with some transparency and honesty about, what your engagement in our community is? So I think there's a lot of difficulty around having the military be involved in at-risk communities in these projects, and I don't think we have appropriate safeguards in place to ensure negative effects are minimized.
The irony is that Kenya is one of the only countries outside of Israel that supports drone strikes by the U.S. It's the public, anyway. Suzanne?
Yeah, I just wanted to take advantage of my position as moderator to ask a follow-up question both to Jayne and Elisa. So both of you, Elisa, at the end of your presentation, you say, we have to be smarter in our counterterrorism policies. In the long term, generally, they're backfiring. So there is, it seems, a short-term benefit. So FATA, for the Financial Action Task Force, many government officials, both in the U.S. and abroad, look at that trans-governmental organization as exemplary of, an effective counterterrorism organization, even at the same time that it has these long-term consequences of crackdowns on civil society. What do you see as the kind of fundamental barrier to the U.S. government thinking in terms of long-term strategies and long-term effects? And how would you suggest addressing that barrier?
Lisa?
She gonna pretend she's not there.
I'm sorry. I was muted. I can't hear the the questions when I'm on the mic. So
I'm sorry. Jayne, can you?
Well, I can repeat the question. Or...
No, I can hear the question.
Okay.
Oh, okay.
Mm-hmm.
No, I just was on mute. Sorry, I heard the question. So obviously, the big picture question: what prevents the U.S. government from thinking long term? That's our government is kind of built to focus on the emergency and the what's within the term of a particular president, or even shorter, a member of Congress. But there are I am not of the view that the United States has to not work with allies in the region who don't have good human rights records. So I don't see this as kind of a binary choice between, we just don't work with those people because they have bad human rights records, or that we, which is I think much more often the case, work with them completely uncritically, funnel money into their militaries and security services, and often don't even publicly criticize when they abuse their own citizens and undermine the strategy for countering violent extremism. So I think, actually, just today, Senator McCain put out a very important statement about the this very dynamic going on in Egypt, and I would urge you all to take a look at it. But he pointed out very rightly that the efforts by the Egyptian government to stifle peaceful dissent, give these long sentences to nonviolent opposition and leaders and journalists fuels violent extremism, and we should not be funneling U.S. government money or pretending that Egypt is moving in the direction of democracy because we need to have their cooperation in the fight against violent extremism. We can do both. And we have to moderate what we have to, be serious about the conditions that Congress has placed on that kind of funding. That's just one example.
I mean, I would say, I would add that the biggest conflict between sort of short-term and long-term thinking in CVE is really between anti-terrorism financing rules and broader engagement. So, I've spoken to a lot of people in Treasury and trying to really get to the, what is actually sort of motivating and, underscoring this approach. And it really is a belief that if you could prevent $1 from going to violent extremists, then that's their job. It's really a very short-term goal measured, in very small outputs. But at the same time, you have a much broader CVE that's actually requiring the government to engage with communities and engage with grassroots and so forth. So those two things are in complete conflict. And there hasn't been a resolution, and it's not looking like a resolution of that anytime soon. I would say, too, the other challenge is that CVE is a long-term question. Building trust with communities is a long-term issue. Human rights, promotion, rule of law are long-term issues. But all CVE indicators require short-term measurement, in terms of output and outcomes. And so you see a real drive among government folks to measure, like, what's the deliverable, what's the output from this program? And people in the community will say, well, this could be years. We're talking, a generation of change here, but CVE imperatives want an answer on a 2-week time frame.
Could I just add one thing to that, Suzanne, and that is the silos in which the U.S. government operates, really contribute to this problem. So you have Treasury, just as Jayne just said, they've got their objective. It's very clear and it's very short term. If you go to the summit, which is supposed to try to get a kind of more whole of government approach, not a lot of people there from the Pentagon, not a lot of people there from Treasury. It's considered sort of a diplomatic thing. And I think and most of the foreign government participants were from, the foreign ministries. So I think that's another challenge, really trying to get this to be an interagency, whole of government strategy.
Next
Let's open up for another question.
And please, if you can, identify yourself before.
If I could dive in with a question, Elisa, you suggested something in my mind when you were talking about President Obama's policy on drone strikes and not being applicable to Syria. That policy that he came out with in the fact sheet talked about requiring near certainty of no civilian casualties. And Andrew, something you said kind of picked up on that. In the whole DPH thing where exempting out activities that people in the military might consider to be DPH, at least in the U.S. military. Do we make a mistake if we don't look at how the adversary is going to react? For example, it seems pretty clear that President Obama's policy, the politics of it, not my judgment, but in terms of how it's going to incentivize the adversary, because if they know that there's not going to be struck, if there's near certainty that the attack won't take place if there are civilians there, that incentivizes them to have civilians around themselves. And if you talk about, not organizing yourself or into an armed group or breaking up the continuity of that membership, that incentivizes people not to be in regular armed forces, not to wear uniforms and so forth. What are your observations about that?
So do you want me to jump in on that?
Yeah.
Okay.
The whole.
I'm glad you raised it, actually, because it is an example of the point I was making right at the outset, which is that, I think we expend a lot of energy in the United States, in the government, and in the in the public debate, trying to address things that really are the symptom of our failure to address the underlying questions, which are really hard, about the scope and duration of armed conflict, who's a combatant and who's not. And Congress is after more than a decade now, sort of waking up to the fact that they ought to be playing a role in that. And you'll hear about that on the AUMF panel, but I really think that is so important because, first of all, I think the president's, policy that he laid out it's a reaction to the sense that there are no clear contours for this war, and so trying to introduce probably overly restrictive in the context of armed conflict, that would be overly restrictive. I mean, this is one of the reasons why it's so important to have these lines as clear as you can make them in, the ambiguous environment in which we're now operating, because between what's war and what's not war. And because we don't have that, we sort of, in some ways, are overcompensating in a way that kind of, as far as I can tell, is prima facie not even being adhered to. Just, as when John Brennan asserted earlier that there are virtually no civilian casualties, and that was just clearly not accurate, and that undermines faith in our willingness and ability to adhere to the kinds of rules for armed conflict that frankly do allow for all kinds of terrible things to happen, including the killing of civilians if the correct analysis has been done. And so I think that's that's a prime example really of the ambivalence that we as Americans feel when we don't have a strong grasp on the scope and duration of armed conflict, who we're at war with and where.
Thanks, Charlie. I mean, we talk about incentivizing this is a fascinating question, actually, because there are a couple of incentives that we can look at. This goes back to if you look at Additional Protocol 1, it was drafted in 1977. It was in the wake of the wars against colonial domination, and here you had it's also in the wake of the Vietnam War, for example, where you have armed groups who are slowly slipping away into the civilian population, intermingling themselves with the full knowledge that provides, as you coined the term, lawfare. This incentivizes a particular type of behavior. That's as old as 1977 at least, and something we've been struggling with ever since. I asked the question, though, what is the alternative? And I don't think we have one out there. But the other incentive, I think, is if you look at Article 6 of AP2, and it talks about granting an amnesty at the end of hostilities for armed groups in relation to their mere direct participation in hostilities. So not an amnesty against war crimes, but an amnesty from that perspective of merely taking part in the conflict. And if that is made clear in advance of a war, or at the beginning of a war, that it's not anticipated that these individuals are going to be domestically prosecuted for merely taking part, then they have a much greater incentive to abide by the laws of war. Because, frankly, if I'm a member of ISIS today and I'm sitting in Syria and Iraq, and I know that if I'm captured by a domestic government, I'm going to be tried for mere participation here. I'm not talking about beheadings here. I'm talking about mere participation. Then what is my incentive not to go to the next level and commit a war crime? And I think that's one of the biggest issues we deal with today. Now, in terms of organization of armed groups and whether there's an incentive to stay disorganized, well, I would suggest that if you have that incentive and you're sort of de facto creating a situation of being disorganized, but you're actually organized, then I would say that you still met the Tadish criteria. You can have cells, you can pretend to be disorganized, but ultimately you're an organized armed group. I think the point of that Tadish law is to say that it's almost an equivalency of means and methods. Here you have a group that requires the use of indirect fire, that requires the use of RPGs, and it requires bombardment from the air. And here you have a group that's a few individuals, like we saw in Canada recently, like we saw in the case of the 2006 underground bombings in London, like we've seen in a couple of cases with the Charlie Hebdo, for example. Here are a few individuals. Is this a law enforcement issue? Is this a conduct of hostilities issue? Well, it really depends on their nexus to, in this case, to ISIS. If we're talking about Charlie Hebdo, what's their nexus to ISIS? Could they be seen as just, now they've walked off the traditional battlefield, but they're actually on the territory of a country that is party to that conflict, which by ICRC's view is now part of the battlefield. So should these individuals be targeted as a matter of status in that country, or should they be dealt with under law enforcement? It really depends on that nexus. I don't think there's an easy answer to it, but it's a complex issue. So I hope I haven't given you too woolly an answer. Yeah.
Other questions? Yes. Go ahead.
Hi, I'm Nick Almond. In relation to Eric Posner's recent book, Twilight on Human Rights Law, and I want to get your reaction. He's been very critical of the impact of human rights law, including its ability to deter conflict involving democracies, and suggests that economic development should take policy preference. This panel has been critical of human rights in terms of U.S. application and implementation. But isn't the picture of human rights law more positive, as demonstrated by the debate we're having today and the operationalization and institutionalization of human rights norms in Western democracies in terms of use of force and military engagements? Or do you share Posner's ultimate conclusion that human rights law is not really an effective tool? I think you might not.
I mean, I think it hopefully should be clear by teaching human rights. I do not share Eric Posner's view at all. I think he has some helpful observations around, being critical of the role of law in making solutions and thinking about, human rights in different ways. I think he has some interesting ideas about, as you mentioned, about development and so forth too. But I don't agree with his characterization of the current state of play. And I think it doesn't take into account at all the realities on the ground and different ways in which groups rely upon human rights law and human rights strategies. We can have a much longer conversation about Posner.
I read the book recently, and I agree very much with Jayne. There are a couple of helpful observations in there about the importance of using development, but it struck me very much as the larger argument of the book as kind of a straw man, and that and also bore the hallmarks of someone who has not spent a lot of time with activists around the world who are fighting for human rights at the front lines of their own societies, that very much value and rely on, and sometimes successfully, the tools that they find in international human rights law. And I think, to talk about the irrelevance of human rights law because governments continue to violate human rights, as I said, is somewhat of a straw man argument. But really, I think I agree with the question that in many ways the very debates that we're having now are a sign about the effectiveness and strength of the human rights paradigm. And that's why I think this conference is so important, because war is supposed to be an exception to that state of affairs, and a forever war risks obliterating that, and I think is an existential threat to the argument in the UN Charter that respect for human rights is the foundation of peace and security in the world.
And I would add to that, I don't work at the intersection of IHL and human rights law, thank goodness, in the ways in which you all do. But I think particularly when we think about CVE as being a much broader concept, right? So human rights law is very relevant to that space. For example, one of the outcomes that we saw from CVE in the UK was that people stopped going to their local mosque. They stopped practicing their religion. They would remove visible signs of religious attire for fear of being surveilled. And so those are human rights questions. And so I think the big lesson, from what CVE means to governments right now, in the US government, but also, quite frankly, around the world, is we're not talking about this pure hard CT model. We're talking about a much broader discussion of what comes under a CVE rubric, and that's where the hard questions are taking place right now. Like, what are the human rights law constraints? No one's arguing human rights law applies, because we're not in this space of targeting and so forth. We're in a much bigger space, and human rights law is determinative of decision-making in that space.
Yes, right behind you.
So I'm somewhat skeptical that we'll get past the point that Andrew highlighted, where the sources and the lexicon that we utilize are no longer in tension. I think that the boxes he drew up there, where he had international armed conflict, non-international armed conflict, and quote peace, are illustrative of that in some respect. You might have noted under his peace box there was a blank space, sort of a dividing line on one side and then a space. And I think that's partly reflective of certain national security activities in which we engage that don't fit neatly in certain categories and may be highlighted by some of the ambiguities that Elisa mentioned. So my question is this. I just returned from an event hosted by the ICRC where one of my colleagues commented on even in those instances where we cannot necessarily agree as to what the law is or should be, that there's some benefit in particularly with respect to civilian populations and pushing on those areas where the greatest harm occurs through policies and procedures to protect the civilian population. There were some comments about, and particularly from Professor Huckerby, about the challenges in anti-terror financing laws, from Elisa about partnerships and the funding and who we give that to. But what else? What other areas might we find some common ground and fill the gaps so that at least our policies and procedures better protect some of the human rights concerns that you have, even if we aren't necessarily going to agree that we're obligated to do so as a matter of law?
Yeah, thanks, Mike. Excellent question. And I mean, the event that you were attending, if I understand, was on explosive weapons in populated areas, and that is an example of the ICRC scanning its delegations in 80 different countries and asking the question, what are the relevant humanitarian issues, and what is the problem that we're trying to address, and then reverse engineer from there. Rather than taking a problem, we saw this with private military and security companies, or taking a subject and saying, let's take this as far as it can go. We now stopped on that issue and said, okay, actually, we're not getting much feedback about humanitarian impact in the limited field that we're looking at on PMSC. So we took a little bit of a step back there, and then we jumped into, okay, let's talk about indirect fire. Let's talk about explosive weapons in populated areas, and let's look at state practices, and let's try to come to, we don't even have to come to a conclusion, but let's discuss what are some of the key issues that arise, and you know, some of the discussion as to the last Gaza conflict this morning, I think, are really illustrative of those challenges. And definitely we need to be having that discussion. The whole dialogue on direct participation in hostilities probably began, and Michael, correct me, I'm sure, on this, but began from ICRC's perspective out of the notion that the operational commander was being given too much of a leeway to decide who was a member of a non-state armed group. It started with the DPH and the actual when the civilians crossed the line. But also, I mean, it also appeared from our perspective that when we're talking to militaries on a routine basis about protection of the civilian population, everybody agrees. Let's protect the civilian population. But if your notion of this, if one's notion of the civilian population is that it's anybody who's in proximity to an armed force, and there's a bad guy or there's a financier, we end up in a sliding scale, which ultimately gets you to where General Sherman was in the Civil War. Of, you know, if you take out the cotton crops, then you have no means to produce uniforms, and at a certain point it slides right down into encapsulating all indirect means of participation, from propaganda to billeting soldiers to whatever it might be. So we're trying to draw that line, which is, of course, with the benefit of the provisions that were already contained in the law. But as you know, there are a number of other projects that we've been putting our fingers on, and a big one right now is detention. You had the International Conference of the Red Cross and Red Crescent in 2011, came to the conclusion that if you look at the entire corpus of IHL, the biggest problem right now sits in terms of the procedural safeguards and guarantees and judicial safeguards that are available to detainees in non-international armed conflict. All you have there is Common Article 3, in some cases AP2. You've got some customary law. You've got AP 175, which is deemed customary in both contexts. But that's it. And then, you know, Yelena Page wrote an excellent article about procedural safeguards, but that was all a matter of policy. So now ICRC is reaching out to states around the world and has had a number of different platforms where we've discussed this issue, and it's still an open question as to where that will go. But by 2015, at the next conference, we should have a very good document to work with and see what can be done on the issue of procedural safeguards. But here I'm talking about, you know, in international armed conflict, you can hold people. You can hold civilians, for example, under the 4th Convention, but they have to be visited. They have to have a hearing every 6 months to ascertain that they continue to be a threat. We don't have anything.
Let's hear what Jayne.
Yeah.
I think Jayne has an
We've got a few ideas on human rights challenges.
Yeah, I'm sorry.
So just very quickly, so additionally to what we've already said, I do think anti-terrorism financing is the biggest overarching challenge that everyone knows and no one's really dealing with in a concrete way. I want to echo a point Andrew had made about issues around return of foreign terrorist fighters. We have a huge problem right now in that families are not prepared to encourage people to return because of draconian laws that are not differentiating between what people did or didn't do in Syria and Iraq. So Australia, the UK, to some degree the US have been really setting up quite prohibitive barriers for encouraging appropriate return, and that's a huge human rights challenge. A second challenge is really how do we support local actors on the ground who are capable of supporting change in ways that are not dangerous or counterproductive. So women in Iraq and Syria could have told you nearly 2 years ago about what was happening with young men in their community going to join and sort of different extremist groups and ultimately joining ISIS. They were not listened to, they were not supported in any way at all, and that's a human rights challenge about how do we engage these early warning systems in ways, again, that don't over-securitize those groups. And a final human rights challenge is we need to stop talking about violent extremism only in terms of ISIS, AQ-inspired groups. There is a broader range of violent extremism that needs to be addressed as violent extremism, and I think that's going to have huge implications for broader counter-narrative and so forth discussions.
Well, I'd like to thank the entire panel for a very wide-ranging and very interesting discussion. Thank you so much, and Lisa, thanks for joining us.
Thank you.